Well, in any event, I'm just going to turn it over because I just wanted to thank Judge Bibas for sharing his time with us. So please welcome Judge Bibas.
Thank you, Dean. Thank you, Addie. Thank you, Professor Blackman. Thank you, FedSoc, for having me here. Couple of shows of hands. First of all, how many of you are one-ups? All right, a good number of you. And how many of you have kids? Not many of you. Okay, so something to look forward to. Let me rewind and tell you. Let's go back just over 7 years ago. I had made it through the vetting process by the president, and the president was about to announce that he wanted to nominate me. So I was sitting at dinner with my wife and my kids, and I told them that the president wanted to make me a judge. And so my son, Harry, who at the time was about 9 years old, said, "So do you get a hammer?" I said, "It's called a gavel." And then Max said to me, "So do you get to carry the hammer around town?" I think he's got this image of like Judge Dredd crossed with Thor or something. I don't know whether the cinematic universes line up. No, I don't actually. So I brought the kids, we pulled them out of school, and I brought them down to Washington, D.C. for the day of my confirmation hearings. It was a pretty educational little field trip for them. And then the senators were asking me what experiences really prepared me for the bench. So I gave them some examples, some cases I had litigated, argued in the Supreme Court and in trial court. But as I reflected on this afterwards, I realized that the thing that really prepared me to be a judge was having multiple kids. And the longer I've been a judge, the more I've found myself wagging my finger at litigants and saying, now, you guys get along and play nicely. Turn over the discovery and we can all play together. Sometimes I just need to schedule a hearing about the dispute so the parties realize that Dad is actually paying attention to their bickering and they'll resolve the issue before the hearing. So, having been a judge for now it's 6.5 years, I want to give you 4 lessons I've learned about how judging is like parenting. To help you better understand both the stage of life you might enter soon, but also the profession that you're entering. And in the process, maybe give a little bit of a tour of the 1L curriculum. I'm going to talk to you about the importance of equal treatment, both actual and perceived. The need for clear rules that we enforce consistently, which is a FedSoc favorite. By the way, FedSoc's a great organization. If you guys are not yet involved, I encourage you to get involved. Third, the commitment to giving parties fair notice and an opportunity to be heard, which is really the backbone of civil procedure. And fourth, the importance of humility. It's a really meta life lesson. So my first lesson, equality. What does it mean to treat like cases alike? So as a dad, I really has underscored for me the importance of not playing favorites. And this can be kind of tricky, So I have 2 boys and then 2 girls. And my first girl, Ella, she's sweet looking and petite and blonde and looks so innocent. And her slightly older brother, Max, can look really surly and guilty. So I'm tempted to stereotype him. But as soon as she learned that, she learned she could frame Max for whatever crime or wrong she get away with. So I was quickly disabused of this. Like stereotyping goes bad directions. And it also really undermines your authority with the kids. It's important not only not to play favorites, you must even appear to play favorites. So, buying Christmas gifts, common occurrence, right? Well, it's really important to make sure you're not splurging on one to the exclusion of the other. But there can be some problems. One kid really wants one big expensive thing. Well, if you give that kid one thing and the other kid 3 or 4 cheaper things, it might be perceived as slighting the kid who gets fewer gifts. So, trying to be attentive to what equality means in these situations from their point of view is really complicated. It also means teaching them life lessons you learn now that you're in law school, you're budding lawyers. But things like taking turns, waiting for someone else to finish a statement and then responding to it. And taking turns is not something that is innate. By the way, you learn with kids, even common sense is assumptions, we can be manipulated very easily, and appearances often are not what they seem. Equality also means on my own side, I have to avoid hypocrisy. It's easy to tell the kids, you know, you've got to eat several vegetables, and you don't get any dessert until you eat it all. Well, if I'm then sneaking dessert later on, oh, heaven forbid, that's going to undercut my authority. I have to be really careful about the rules that I lay down and appear to follow them very consistently. If I draw distinctions among the kids, well, sometimes I do need to draw distinctions. But if I do, they've got to be obviously relevant. I've got to explain them, apply them consistently, and announce them ahead of time. So, my eldest is now 16 and a half years old. He's running cross country. He comes in and wants to eat 4 or 5 helpings at dinner. And then my 11-year-old girl, Katya, says to me, well, don't I get to have 4 or 5 helpings? Now, how do you justify that rule, which is he's a teenage boy who's running cross country, who's 5'11" and a half right now. You know, you don't need to eat as much as he does, right? So I can articulate it, but I need to make sure when I start doing the differential treatment that I'm ready to back it up with those kinds of reasons, okay? So I can react to them with distinctions that I can justify. But it's not okay for me to react to one kid differently from another because I'm irritated with this kid, or angry at that one, or frustrated, or as I suggested, because one of them seems cuter at the moment, right? Again, that's a recipe for manipulation and disaster. So this is actually a pretty good guide for judges. In fact, that's how Justice Scalia, who was the late great Justice Scalia, was the father of 9 children. He knew what he was speaking about. He wrote a very famous essay called The Rule of Law as a Law of Rules. And in that, he said, quote, parents know that children will accept quite readily all sorts of arbitrary substantive dispositions. No television in the afternoon, or no television in the evening, or even no television at all. But try to let one brother or sister watch television when the others do not, and you will feel the fury of the fundamental sense of justice unleashed. And we've certainly learned that. We want to be strict on television, so we've got to be evenly strict. When you start carving out exceptions, you got problems. Let me give you some examples that you're going to encounter in the law school curriculum. In constitutional law, you may run across an example from World War II. There was a case, Korematsu, where the government decided it wanted to lock up not only Japanese nationals, but Japanese Americans in internment camps in the West. They said, well, we're really afraid of them. Well, why aren't you locking up the German Americans? Why aren't you asking about their loyalty or connection to other countries? You know, are Japanese Americans who were born here in this native country and citizens, are they in the same situation? We now look back on that as a terrible failure of equal treatment because it wasn't a distinction that was really justified. It was based on fears. Look back in World War II, another big dispute that, you know, was over making people pledge of allegiance and say it in school. And at the time, with the fear of godless communism, you know, the phrase, you know, soon the phrase under God was added to it, but there were some minority religious believers, the Jehovah's Witnesses, wouldn't say it. And at first, the Supreme Court said, well, that's okay. But then, to its great credit, 3 years later, the Supreme Court changed its tune and recognized in Barnett that even unpopular folks, Jehovah's Witnesses, have the same free speech and free conscience rights as others. Or Strawder versus West Virginia, where, you know, prosecutors were excluding jurors of the defendant's race just because they were black, denied the defendant equal protection of the law. So, being equal means not just substantive justice, it means the appearance of justice. So, just as I tried to learn as dad, I've got to explain what I'm doing clearly and succinctly in kid-proof terms, right? And that's a good rule of dealing with lawyers, too, by the way. If you phrase it in kid-proof terms, even the lawyers can't. It's harder for them to twist or misunderstand what you say. Sometimes I even need to do some lawyering for the unrepresented party. You know, when you've got a pro se litigant, it may be important to question the witnesses for them. We'll make a point of appointing some lawyers for them, but we in general have to bend over backwards to make sure that we hear an equal argument from both sides, especially if the one party doesn't have a lawyer. But my point about not being a hypocrite as a dad applies equally as a judge, being scrupulous about following the rules myself. So the recusal rules we judges have are very strict. Make it loud. I think back, maybe it was 3 years ago. I was in Washington, D.C. I was moderating a panel at the Federalist Society conference. And then I think it was like fall of 2021 or something. So we'd been like a year and a half into COVID. D.C. still had mask mandates on the books. A lot of people weren't wearing them. But I was a judge in a federal place, in a public place where the rule applied, and I shouldn't be seen violating this rule. Because what are the litigants going to say about, oh, he's got this attitude towards the laws and all of it? And we see now what happens when you have people who lay down mandates for other people that they won't follow. So it's really important for us judges not to do stuff like go and jaywalk or double park or things like that, because you never know who's gonna come around and watch it. So the second lesson I learned as a dad is the real importance of clear rules, not just mushy standards. So I tried saying to my second son, the troublemaker Max, your room needs to be clean, okay? Well, I come in there. There are smelly inside-out socks. Well, they look clean to me. They're white, right? And when I lay out that clean standard, who knows what I'm going to get? My daughters are going to interpret it one way. My sons are going to interpret it a different way. I've learned if you give the kids dessert or the playtime, etc., before they've cleaned their room, before they've done the house cleaning, you may not get compliance. If you've got a rule, you are going to finish your homework before there is any screen time or games. You are much more likely to get compliance because you communicated it. If I want a clean room, I have to use specific items and make it stick. No underpants, socks, or any other garments on the floor. Okay? That can be defined more objectively. Kids, by the way, are natural lawyers. So I tried saying to Max, don't throw the ball. So he would look at me and drop it. Very little. So, by the way, I hate to break it to you. You guys are going to be lawyers. Your kids are going to inherit lawyer genius.
Yep.
And what that means
True.
is that they are going to
It's
do
true.
unto you what you did unto your mom.
It's true.
I hope it breeds a sense of humor and appreciation for what your mom and dad put up with. Finding ways to take arguments on everything, because I have to say that's
true.
the curse of lawyer genius. It makes you appreciate what mom and dad did all the more. So the same rule applies in judging. I find that where our law has these multi-factor balancing tests, it breeds litigation and clever lawyering and inconsistency, and it puts a bridge in the parties who have money to litigate these issues. So think, you want to, you're learning contract law, and when it comes to contract formation, we have a relatively clear set of rules about offer and acceptance. And we base this based on the objective understanding of what makes a contract. Your professors may be exploring the few edge cases, but in most cases there's a rule for when you put the letter in the mailbox, or when someone signs on the dotted line. One of the examples that gets used, the great Judge Learned Hand in Hotchkiss made clear that a contract has strictly speaking nothing to do with the personal or individual intent of the parties. If it were proved by 20 bishops that either party, when he used the words, intended something else than the usual meaning which the law imposes on them, he'd still be held to the contract. So there's a great case you're going to read, Lucy versus Zamer. There are these two farmers. One of them is wanted by the other one's farm for a long time. They're out drinking, but they're not drunk. And one of them says, I paid $5,000 for that. No, you wouldn't. I paid $50,000. And they ultimately wind up writing out a contract on the back of a napkin and signing it. And the parties were, the evidence came in that the parties were not drunk or not incapacitated. The other farmer later said, it was a joke. I didn't really mean to sell it, but he had insisted that, these were the terms. He had dickered over the money. They had written it out. They had signed it. And the court ultimately held him to his bargain. And so there was the formalities like something being in writing or signing on the dotted line where people can understand, they can rely on that. They don't have to be psychoanalyzing the person they're contracting with. Or take the finders keepers right. So I bet you didn't realize you were learning contract law or and Levin when you were on the playground. And people would say finders keepers. Well, in Armory versus Delamere, you're going to learn about the chimney sweep. Goes out, he finds a jewel while he's sweeping his chimney. He goes and brings it to a jeweler. Says, "Give me an appraisal." The jeweler says, "I'll take a look at it. I'll give you half a pound, I think, English money. No, 3 half pennies. property has a claim that's better than anyone else's. And if this reduces the ability of people to exploit it and say, you don't really have legal title, let's have to go into court, let's have to litigate it. And the clear rule in that situation just cuts down so much on the amount of dispute we'd have to resolve if it were really up for grabs. Whereas in my field, so criminal procedure is what I taught and still teach sometimes. There's a bunch of messy areas of law. The confrontation clause. It used to be in Ohio versus Roberts, we had to balance whether the defendant's rights are up against a particularized guarantees of trustworthiness, judges at 7 or 8 or 9 factor balancing tests. It just led to inconsistency. It led prosecutors to strategically lock in testimony. The Supreme Court got rid of all of this before you were born in Crawford. And thankfully you no longer have to learn it for the bar exam. What you do have to learn in Civ Pro, though, is the test for personal jurisdiction. International shoe. You know, when we interpret due process for personal jurisdiction, you can ask Civ Pro experts, what are sufficient minimum contacts to a forum? Like you ask 6 different professors, you'll get 8 answers. Well, how do we determine traditional notions of fair play and substantial justice? I still don't know. I'm a federal judge. So we have these tests. The Supreme Court's told us to apply them, and yet we can't help but apply them messily, just because we don't have the right rules in place. Clear rules, by contrast, encourage dispute resolution and settlement, and they let conscientious people follow the law. They let them avoid litigation. Makes it easier for us to communicate in short, clear opinions to them. All right. My third parallel between parenting and judging is notice and an opportunity to be heard. So, by the way, one of my clerks got to my clerk's and said it wasn't until I told him about this, he actually understood, that this principle underlies everything you learn in Civ Pro. All of those complicated rules are really just to ensure that people know they're being dragged into court, they know why and for what, and they have a fair chance to put on their pieces. Now, as a dad, I've learned, as I told you about the room cleaning example, clear rules keep my kids notice. At the same time, notice means I mustn't jump to conclusions or act out of anger. I have to give Max the fair warning about the smelly socks on the ground before I can levy a punishment. I've got to keep an open mind. Occasionally I discover that the broken thing on his floor is actually because his brother ran into the room to wrestle him. And so I can't then punish him for breaking the thing. And kids and lawyers, sometimes they make some good arguments. I have to give them a chance to express their preferences, even though it's not a democracy. Make clear it's not a democracy, but also make clear they will be heard out. And don't let, by the way, the louder, more persuasive child dominate the discussion. When you have multiple kids, one thing you'll learn is some of them will keep talking and talking and talking. It's those lawyer genes again, until you make sure the other side gets to respond. Well, hey, the principle works in court. Our legal system's rules, unfortunately, aren't, in so many cases, clear enough to give fair notice. And they should be clear. From crim law, which I used to teach, the central issue is often mens rea. You gotta have a guilty mind before we punish someone. And that was long central to criminal law. Unfortunately, we've been undercutting that with more and more strict liability exceptions to it. So, there's an example. A case in Washington, D.C. The man was the superintendent of one of these nursing homes, or retirement homes. And their sewage started backing up. So he wound up throwing some sewage, which he thought would send the sewage to an alternative pipe. In fact, he wound up sending it into the Potomac River. But no one says that he knew or even that he should have known where it went. And this man who had a very clean record for his whole life, they're able to convict him and give him a criminal record without showing that he had any mental blameworthiness at all. This should trouble us. We keep spreading criminal liability in a way that might water down its moral force. By the way, we also have so many costs to raising these claims in court that it deters people from being heard in court. Litigants often don't have lawyers. A third of people wind up not hiring lawyers for their disputes. People have grievances. We have mentally ill litigants who have a hard time being understood. And so there's a lot of problems. Access to justice is too expensive and too difficult, especially given the lawyer monopoly that we have. We need to work harder to give more people their day in court and lower those barriers. We also need to listen respectfully to them, address them seriously, and speak to them in plain English. If we're clearer, speaking clearly to them. Yes, we've heard you. Here's the principle we're going to try to follow it consistently, and we are keeping an open mind. If we do that, we treat the litigants with respect and empathy. The way we do justice is as important, I argue, as what we do. That's something you learn as a dad. You may have to punish someone, but you ought to make them feel like they've been taken seriously and not belittled, right? There are many criminal defendants and immigrants who come into my court, and empirically, the large majority of them are likely to lose. In our immigration law, by the time they get to us, there are relative defenses of deportation. I don't think my job as a judge is to twist the law because I feel bad for them. But I do think I can make them feel heard and respectful. I can address their key arguments without being snide or condescending. The same thing with criminal defendants. We can also, in trial courts, give defendants an opportunity to apologize, just as we require our kids to apologize to one another. They learn some lessons from it. It's something in other work I've argued that our sentencing procedures should allow more. But the final lesson, and this sounds odd, is humility. We don't associate humility with lawyers, all right? And this is interesting because I'll bet there are some people in this room who maybe, as a religious matter, believe humility is a good thing, but then you turn that off from Sunday, and then you go to Monday, and then suddenly lawyers are kind of chest thumping and proud and arrogant as we are caricatured to be. And I don't think it should be that way. I also think it's not a great strategy for being a dad or for being a lawyer. So as dad, I think one of the foundational things you've got to realize is that you've got this daunting obligation on your shoulders. Becoming a parent should change you ontologically. You're not born a
true.
or a mom, but you got to grow into it and pray for guidance. That does not mean that you get to be a dictator, right? Now listen, you've got some things to learn from your wife or other parents, or even from the kids, as I suggested. You must have these fantasies of treating your kids like clay. I mean, what is it? The My Fair Lady conceit of
Pygmalion.
Henry Higgins is going to remake Eliza and do a little like your kids. Just as I like to say, Clausewitz said, Adam plans never survive contact with the enemy. So Bibas's corollary to Clausewitz is parenting books never survive contact with actual children. And that's because the weird genetic lottery of who you wind up getting. You have to be humble about accepting what you've been given, not that you're going to mold them into your image. You're going to make them all little litigators just like yourself. But rather, it's a trust from God that we are not infinitely perfectible, and we're supposed to cultivate what we've been given. Well, the same thing, I think, is a good lesson for judges. There's a syndrome called black robe syndrome. Judges sometimes get really huffy and expect a certain level of deference. And there's some deference that is due to the role, but it risks going to our heads. And we have to be careful not to embrace the job for our egos or for the fancy title, the honorable this or that. It's a weighty responsibility. So when you go through the judicial confirmation process, one thing you start thinking about is, okay, who are my judicial idols? What judges do I look up to? And I reflect on and increasingly came to admire the late, great Justice Robert Jackson, who had an amazing career. The man came from a humble background in Western New York State. He put himself through night law school at Albany for a year, and he wound up becoming Solicitor General, arguing before the Supreme Court, Attorney General, Supreme Court. He actually took a year off the Supreme Court to go and be a Nuremberg prosecutor. But Justice Jackson wrote, the road changes a man, or it should. And I think embracing that sense that, yes, I've got to change, I've got to grow into these robes is an important trust. Just as you're not going to feel like a lawyer the moment you take the bar exam. Like there's a lot of judgment and prudence that you're going to have to grow into those shoes over time. There's also a value as a judge of resting on law that's beyond my own will. That's one big reason I think it's very important to look to the original meaning of the Constitution, or to look to the text of a statute, to look to precedent. Justice Scalia, in his book with Brian Garner, which you should all read, writes about how originalism is humble. If we follow a living constitutionalist approach, we're going to be philosopher kings. We usurp the role of the people, the voters in our democracy, to update the laws. It takes humility to stay in our lane, to faithfully faithfully fulfill our role as judges. But at the same time, it's kind of liberating. Sometimes people ask me, how can you deport people? Well, it's not my job to play God and decide whether this person belongs here or not. My job is I've been given some legal claims, I've been given some facts. I can treat the person with dignity and respect, but at the end of the day, my job is not to twist the immigration laws or the criminal laws or whatever else. They didn't choose me for that. I'm not representative for them. I'll give you some examples from some great decisions. So, many people look back at Justice Holmes' dissent in Lochner, where he said, I strongly believe my agreement or disagreement with this law has nothing to do with how I decide this case. And whatever you think of the case, the sentiment is a very important one. Chief Justice Rehnquist wrote in Glucksberg, a decision 9-0, the Supreme Court rejected the right to physician-assisted suicide. Quote, throughout the nation, Americans are engaged in an earnest and profound debate about the morality, legality, and practicality of physician-assisted suicide. Our holding permits this debate to continue, as it should in a democratic society. And finally, Chief Justice Roberts, writing for the 4 dissenters in Obergefell, it can be tempting for judges to confuse our own preferences with the requirements of the law. But as this court has been reminded throughout our history, the Constitution is made for people of fundamentally differing views. Accordingly, courts are not concerned with the wisdom of policy or legislation. I think striving, it's an ideal, we all fall short of it, but striving to learn from colleagues is part of that ideal of humility. They have some things they could persuade me of. I could learn from them if I try to keep an open mind. Now, I want to be clear. I am not one of these people who thinks that judges should have minds that are so open that their brains fall out. Or as Harry Truman said, I want a one-handed economist, because every economist who comes to me is on one hand and the other hand. So I think being humble is consistent with being decisive. At the end of the day, it's my job to decide. Okay? Sometimes the parents just need to decide where we're going for dinner, what movie we're watching for family movie night, right? And judges need to decide cases. But you don't decide until you've gone through a fair process. You've listened to the parties, you've listened to the colleagues, you've reflected a little bit on it. You should even listen, by the way, in my opinion, to your law clerks. And I think that's an important part of my process as a judge. I encourage you all to think about clerking for judges. You'll learn a lot from the way that a judge approaches cases. So I think it's very important that I collaborate with my clerks and edit back and forth until we get the right answer. I had the privilege of clerking not only for Judge Patrick Higginbotham, but for Justice Anthony Kennedy. And my year with him at the Supreme Court, he'd have a whiteboard on an easel, or a big pad of paper or something, and the 4 clerks would sit around and if we went this way, what would that be like? And someone would start sketching out, and people would start firing objections. Well, what if the law were like this? And so just trying on different hats to see how this would work and fit with the existing precedent, how this would work, was a huge part of learning the case for him. I had some cases like that where it was incredibly helpful for me to have all my clerks sit around. So I don't know if you know, around the country, COVID was a bonanza for litigators. One way in which it was that all these universities and colleges went remote. However, they did not decide they were going to refund anybody's tuition. And so a bunch of lawyers started suing them. And a case landed in my court, which was, well, I take a few trial court cases. So how about the University of Delaware students who, in the middle of the spring 2020, discovered their classes had all gone remote? What had they contracted for when they signed up for college? And by the way, it stuns me that when you pay tens of thousands of dollars in tuition, you don't get some detailed contract with a whole lot of clauses, and a force majeure clause, a whole bunch of other things. So we had to cobble together what were the contractual documents here from the college view book, all the photos of thoughtful students in classrooms and students in dormitories. And I had half of my clerks were convinced, no, all you contracted for was that you would get the BA on your resume, and you would get to go through graduation, you would get to say you were a college graduate. And the other half of my clerks who were arguing very forcefully, no, people pay more because they know they're going off to college for the group experience of being in college. And the state law that we were applying, Delaware law, did not have any particular, burdens of proof or presumptions against these things. things, and at the end of the day, I thought, well, on a motion to dismiss, I don't think I can toss this out. I thought it was plausible under Delaware law that there might be an implied contract here. But it was really helpful hearing the different perspectives people brought when they imagined themselves contracting for their own college education. And I think, by the way, another better principle, free speech is an essential part of that. I try to hire people who will voice opinions and not shut down unpopular or politically incorrect positions in chambers, because only with that kind of argument disagreement can you hash out the weak parts in each side. In conclusion, I think as a parent or as a judge, you've got to realize that you can't fix the world. And you're gonna give yourself an ulcer if you think your job is to fix the world and do cosmic justice in this job. You can only do your part. But embracing that as a parent, embracing the limitations as a judge, means not perfect justice or not perfecting your kids, but at the same time, it's liberating, realizing what you can do for them. I thank you all for your attention. I'd love to ask some questions. I'm honored, by the way, to have Judge Elrod here. So thank you for gracing me with your presence.
She does not have black robes.
I thought the barbarian wants to ask any questions, or honestly, you might be loud enough for your seat. Sheldon, you wanna ask?
Yes. Thank you for being here, Judge. I had a question about what do you consider as a father and a judge trying to appropriately manage your authority, considering people's lives, your children's lives are in your hands, and people's businesses or people being behind bars for a long time is in your hands. How do you appropriately, what do you consider when trying to manage your authority to give justice but also have some barriers?
It's interesting. So my day job is on a court of appeals, where most often we're presented with a binary affirm or reverse decision. That becomes more obvious. I have been sentencing a couple of dozen cases recently, and criminal sentencing is a place where it really does cash out. And that seems more closer to what I do as a dad, where, we decide very carefully we're going to lay down certain lines, but only certain lines. I've learned that trying to micromanage my kids is a recipe for disaster. It's going to blow up, and if I don't differentiate the big stuff from the small stuff, I will sometimes get one of my goody two-shoes kids will say, well, but he's not doing X the way you asked him to. Like, okay, I'm not going to blow up over the fact that he hasn't yet brushed his teeth and I asked him 30 seconds ago, right? Now, if we're at bedtime and he hasn't brushed his teeth, it is appropriate to make a bigger deal out of it. And at sentencing, I have even less wiggle room, in part because I take sentencing guidelines and that kind of guidance pretty seriously. In part because I think as a dad, there is this presumption of love that means that the law takes a very hands-off approach to what parents choose to do. Certainly it should, in my view, but also historically has. Whereas there's not presumption of love when I'm sentencing someone to go into prison for a while. I do try to establish my bona fides. I try to make it really clear I'm not judging your soul. I'm not judging you in an eternal sense. I'm attaching the consequences that you deserve for this particular act, but there are many more acts or chapters in your life, and what you do with them is up to you. So, trying to make clear that it's not something personal or that I really do think we should be primarily punishing the act, not primarily the actor. But some of it's about articulating what that limited role is so people don't labor under misapprehension. He's doing it just because he hates me or something else. And by the way, if you don't explain your rulings or decisions enough, people will draw those lessons. Now, when you have kids who are lawyers' kids, they'll go to the other extreme and they'll keep asking why. And after about 3 or 4 of these, my wife's stop response is because I'm a mean and nasty person. Which means, okay, I've given you all the explanation one could reasonably give for this decision, and now it's time to comply.
What's the most difficult thing that you encountered in your time
child court cases are definitely the worst ones. They are long sentences, and by the way, before I took the bench, I thought of child porn as like just Playboy with getting underneath. This is like kids who have been molested and abused, and sometimes it's by relatives or friends. And I think one of the really hard things is, as a dad, my initial instinct is, I want to throttle this person. And you can't judge in that state. You've got to like calm down and some detachment and like, you know, I'm doing this on behalf of society. I'm not doing it about my kid or whatever. But I gotta recognize that there are victims out there and a bunch of indirect victims and they're looking to justice, and I can't erase the wounds the kid felt. But there is a measure of justice to be given, and it is unfortunate that so many victims of sex crimes feel victimized again by the justice system. So I have to take serious of that, including like trying to do whatever we can to keep any hint of who this person is, like full name, out of anything public, you know, redacting things. But it is a horrific set of cases, and it brings you face to face with much of the breakdown in our society that these crimes happen so prevalently as they do. So it's not all glamorous, it's not all constitutional cases. There are many yuckier parts of the job like that. And you know, there are a lot of crimes and family situations that bring you into really sad situations. I'm trying to remember, every unhappy family is unhappy in its own way. You know, every crime is unhappy in its own way, and every familial one is unhappy. So it's something on the one hand, part of me loved about being in criminal prosecution. It's always interesting, exciting, but you've got to have a strong stomach for that. Yes.
You said as a judge that your job is essentially to apply the law and not advocate for one side or the other. Is there an area of law that you wish you had more wiggle room in order to do something like that?
Look, I've got suggestions now and again for this area of law seems to be messed up. I have written some concurrences like, you know, maybe Congress might think about fixing this. Maybe the Supreme Court would clean up this mess this mess of the Federal Tort Claims Act. I don't think it should come out and say mess that they have made. But you know, that this area of law is a mess, I can sometimes articulate like, no, it's not that you're dumb, it's that it's genuinely inconsistent, and that's why it's hard to understand what it is. So generally the best I can do is kind of clean it up, because if it's a mess, the people with bad lawyers wind up suffering because they have a harder time navigating it. So I clean up what I can, and then, you know, once in a while I have something to add to this that I might write as a separate bit of concurrence. But we gotta be careful when we have something worth saying. It's not just me sounding off for the sake of hearing my own voice.
Well, can you explain to them how it is that you're doing sentencings right now, since you are?
Oh yeah. So you might think about this. When I was in law school, people said, well, you could do a trial court clerkship or an appellate court clerkship. And it might be neat to do both because they're very different. The appellate work is maybe more intellectual, more bookish, more writing. The trial court work is much more being in court. You have clerks might be dealing directly with lawyers and seeing a lot of witnesses, the good, the bad, and the ugly of lawyers. So I'm on an appellate court. Our dockets are actually down significantly post-COVID because a big backlog developed at the trial level. And so, not enough work. I decided to volunteer and help out some of the trial courts in our area. And I think since there was a venue decision that rerouted a lot of patent cases from Texas to Delaware, Delaware winds up with just 60% of its docket is now patent litigation because so many corporations are incorporated there. And so I've helped out. I've taken some cases from there. I've taken some cases from New Jersey. And it's part of my remedial education because I never was a trial judge full time. But I've, you know, having written for several decades about plea bargaining and sentencing and things like that, now I get the experience of doing it. And it's a good thing to realize that. One thing I'll tell you is I really understand now why we are so deferential to district court judges on abuse of discretion or clearly erroneous standard of review. So if you ever have an appeal, rule number one is do not just rehash the arguments that lost in the trial court. Because we're going to trust them when it came to believing who was telling the truth and who was lying, right? What you might get them reversed on you run across situations for which there is no rule of law, like the judge has to kind of improvise, take his or her best guess, and we can't be fly-specking those kinds of decisions, which are often made under the pressure of a trial or something.
Oh.
Yeah.
Judge, you've mentioned about the struggles you've had when it comes to dealing with regulating your emotions and being impartial, but is there a time you can think of when you truly felt the gravity of your decision making and the prospects that
Well,
come from it?
it is by far most immediate at sentencing. At sentencing, you've got the defendant there, you often have a bunch of defendant's family there, sometimes you've got the victim there, and so it's a very dramatic courtroom scene. So that's clearly the one where it's most immediate. I mean, we decide cases where it's clear the stakes are really big, etc. But the appellate process kind of is much more reason than emotion, and it's much more about what these cases say, etc. And I'll tell you, every appellate judge comes back sometimes and chuckles about, yeah, we got that jury lawyer in here now and giving his jury some speech and doesn't realize the audience he's talking to, where that what might work by playing on the heartstrings before a jury just is really not going to work in the appellate court. So we recognize these are big, important cases, but the way that they are argued and heard and briefed kind of lowers the temperature, so it's a much more kind of sober, reflective process. That's not to say that we don't realize these are big cases, but I think it's driven home to you by having the defendant and the victim in a courtroom in a way that it isn't really in an appellate court.
Professor Jankowski, did you have a question?
I do. I want to make sure there's time for students, but so I'm with you on clarity, both in parenting and in rules and laws made. I like a good bright line rule where it's very specific, but I'm wondering, is there still a place for the more squishy, more discretionary factor-based tests, or should we just try and get rid of those to the extent possible?
It depends on what. I mean, I think at sentencing there needs to be room for both, which is relatively predictable range, but some real adjustments within the range and occasionally outside the range, right? I think everyone knows that's the case, that you want the rule of what not to do to be relatively clear, and there have to be some consequences that will predictably follow. But we allow our kid, like, okay, when there's a sincere, contrite apology, maybe at that point you're fit to come back to the dinner table or something like that. But when it comes to like the primary rules over what to do or how to behave, those are ones that I think if we want non-lawyers to abide by them and navigate them, they need to be clearer. I have to say I'm not an expert on tax. I think there's a difference between intricate but individually clear rules, which probably works better in the tax context than it does in like the Fourth Amendment context, versus like the search rules for searching containers versus bags. What if you take the bag and then you put it in the trunk of a car? Do you follow the car trunk rule or the bag rule? There's a whole bunch of these sublaws that we're expecting cops without law school training to be applying on the road. And the Supreme Court developed a whole bunch of this stuff, and then it allowed some of it back in Gant. But I think it's expecting an awful lot of police officers to have, either you go to a straight reasonableness test or you go to a straight warrant test. But the like in between that we have of those two can be really confusing, unless you're then going to undercut it all in the back end and say, well, good faith exception, it all winds up coming in, which is kind of where it winds up, but you're not really laying down some clear markers, right? Eventually the Supreme Court got there and they said like, okay, cell phone searches are different. You can't just go prowling the cell phone. Like, good, okay, we can teach the officers. Don't just open up the cell phone or the iPad and start going on a fishing expedition when it's a traffic stop, right?
Okay.
Yeah.
Yes.
I had a question about when you spoke about the access to justice. I don't know much about, I'm an L1, so I don't know much about, filing fees or how much anything costs. But what are some of the most glaring issues that you see in the access to justice going on in your jurisdiction right now?
Okay, well, I won't tell you, it's not so much in my particular court. much bigger issue in state courts, but of people who have a legal dispute, let's focus on civil ones for the moment. In our country, 30% of people just lump it and never seek any recourse. And in most other countries, there is an option for those other 30% of people. In Latin American countries, they can hire a notario. In places like England, they might be able to get a paralegal. And here we say, if you don't have a JD, you can't do anything to assist somebody, or you get prosecuted for the unauthorized practice of law. And in fact, some of the people who provide legal forms for leases or wills or stuff, some of those companies have been prosecuted back and forth. Sometimes they get to do some of it or not. But I think this is an area where technology is in the process of radically disrupting this. That the technological dispute resolution mechanisms that get used in eBay or Modry or some of these are really remarkable in how cheaply and quickly they can resolve. And 90% of the disputes without any human involvement, just like a bot kind of mediating the two parties exchanging their own positions and working out a settlement. But I think part of it is that we've assumed our procedures are designed for lawyer versus lawyer. So when you get lawyer versus pro se litigant, it's tilted. You can develop procedures that are pro se versus pro se. So like small claims court is designed to be no lawyers, has to be a dispute of less than $6,000 or something like that. Pretty straightforward rules. We're not going to have the rules of evidence or the federal rules of civil procedure. You could design more courts like that and more disputes to triage them out, because the federal rules of civil procedure, honestly, it's hard to get a lawyer to take a case for less than the mid-5 figures. If you have a $100,000 like car accident, okay, you'll get a contingency fee lawyer for that. But for your, my landlord, my tenant stiffed me for $7,000 in rent or something like that, good luck. It's really hard, and we drive the costs up. And we require people to get 3 years of a legal education, even if they want to be like public defenders earning, $35,000, $40,000 a year. It's like, that's an awfully expensive kind of threshold or gatekeeper that you have to take all the civil courses too. Surely we could teach them in some kind of specialized thing in a year and a half. The analogy I like to use is medicine. So I was at a conference on access to justice. I had one of the defenders of the bar stood up and said, if I ever had a medical issue, serious medical issue, I would want only the best doctor to be treating me. And this woman, Robin Steinberg, who until recently was the head of Bronx Defenders, raised her hand and said, I'm a middle-class woman, good health insurance. I've had 3 children, and for all 3 of them, I chose to get a midwife rather than an OB because I thought I got better quality care more humanely than I would have necessarily from a doctor. And so for the low-risk pregnancies, maybe the midwife is a good idea. For the routine cookie-cutter lawsuits, maybe the paralegal or notario or software is a good idea. And maybe we have a set of bespoke, like unusually complex and usually difficult, you've got someone who's mentally disabled or retarded, or there are going to be situations that complicate things, but I think we've tried to squeeze everything into everyone's going to have a lawyer building pleadings from scratch model. And honestly, the cost of running a law firm on your own, you'll discover $200 an hour, the average cost, will kind of keep the lights on and keep your student loans being paid off and the Westlaw subscription, etc. But like those kinds of rates, ordinary people can't come up with $1,000 to pay for 5 hours of a lawyer's time. So as I'm writing about elsewhere, new technologies and now AI are actually some promising ways to help people get access to justice without a full-blown lawyer, but it runs up against the bar's monopoly. And is it ideal? Maybe not, but is it better than getting no help at all? Probably.
Thank you.
I'll ask another question. Oh, sorry.
Last
You
one.
clearly have a very impressive career. What can we do in law school to take advantage of all the opportunities that we're given? Like, how can we make the most of our time here?
Absolutely. I think there's no reason that law school should be 3 years long if you're just going to sit in one doctrinal class after another. Your first it is important to do other stuff too. I think, ideally, if I could wave a magic wand when it came to your law school, if it weren't made optional, it would be made like an apprenticeship, where you were doing externships, internships, clinics, other stuff that gets you ready for the practice of law. And so, if you have an opportunity to work for a judge, or in a prosecutor's office, or defender's office, or some kind of small law firm, or social services organization, something like that where you get your hands dirty, and you learn the complexity, because when you're reading cases in the casebook, these are carefully packaged, appellate cases, the facts are cut and dry, they've been handed to you. But most of lawyering is about investigating, about figuring out what the facts are, and whom to believe, and how you find this, or investigate it, or infer it. And so you are here in a city with a vibrant legal market, with a lot of great judges and law firms and other things. Take advantage of it. Use it. Get whatever course credit they will let you get for the internships, the externships. And another thing, I don't know why, I had a great time. I split all of my summers. So my first summer, I interned for a judge. I volunteered at a political convention. And then my second summer, I was with a law firm, and then I was in the prosecutor's office. And then my third summer, I was at the Department of Justice. And so I didn't have any lawyers in my family, right? Great immigrant kid, brought up working in restaurants, but that's how. Combination of that, and then networking, and FedSoc can be a good organization for that. Getting to meet a bunch of other lawyers, talk to them, ask people, who are alumni of your college, your law school, etc., what they did. How you can find out from your career office. If you know you want to, I'll give you an example. You want to be a prosecutor. You can find people who graduated from here, who went to the prosecutor's office you're interested in, talk with them, shadow them, find out how they got, and maybe they can help you get a foot in the door somewhere. So much of it is beyond what you get in your doctrinal classes. Look around at the jobs, go to the